I'm glad he was able to return this year. Brian is a practicing attorney, a published author, and a proud long-term resident of Grand Lake. He has served as an adjunct professor of law at the University of Wyoming, where he has taught law and constitutional government. He has a new class he'll be teaching next year on, now I can't remember it again. I asked him it again, so he'll tell you what it is. And he has published original scholarship on federalism, international law, and marijuana legalization with the University of Virginia's Journal of Social Policy and the Law with Pepperdine Law Review. He is also, most importantly, the founder and commissioner of the Grand Lake Pond Hockey Classic. He holds a JD and an MA in American Studies from Rutgers University. Let's give a big round of applause to Brian. Thanks.
Well, thank you, Katie. Let's thank her for that great intro. Very kind introduction. I also like to start these events by thanking all the Constitution Week volunteers. They do a lot of hard work all week long to make this happen, and so we definitely want to give them our recognition and our appreciation. So I want to do that personally, but I think we all should, all the volunteers who are here. I also like to start these by thanking all of you for coming out here tonight and taking time out of your busy days and your busy schedules to hopefully learn some new and interesting things about our constitutional history, our constitutional system of government, maybe even tonight relate some of these things to more of our everyday local affairs. Now, as Katie mentioned, this is my 9th year speaking at Constitution Week. I cannot believe it's been 9 years already, how that goes by. But as a nod to that longevity this year, when I was thinking about what I might talk about, I thought that I would really, really challenge myself. I thought that I would really make sure that I have my work cut out for me here tonight. So if you saw the title of this talk, my guess is that some of you are here because you saw the title. It's a nice sized crowd, which I'm happy about. If you saw the title, it's The Killdozer and the Constitution. And now the Killdozer alone, and even just that name Killdozer, could be controversial, and I'm not using it in any kind of judgmental way. I'm just using it as shorthand for those events. But the Killdozer in itself, it can be a controversial topic, right? And around here, it's a topic that almost everyone has an opinion about. It's a topic around here that almost everyone seems to have insider information about. And so that makes it somewhat sensitive. It makes it somewhat difficult to make these remarks here tonight, just on the Killdozer on its own. And then it's the Killdozer and the Constitution. What could those two possibly have to do with one another, right? What is the connection between the Killdozer and the Constitution, right? How am I going to connect these dots, right? It's a difficult topic. And then on top of that, as Katie mentioned, some of you might remember, we're celebrating all year this 250th anniversary of our Declaration of Independence. And the organizers of the whole week asked the speakers if we can to tie in the Declaration of Independence to our talks here at Constitution Week. So I said, okay, I'll try to do that. So we have the Killdozer, we have the Constitution, and we have the Declaration. How in the world am I going to connect those dots? Right? What in the world do those three things possibly have to do with one another? So, as I said, I made sure I gave myself a challenge here tonight, made sure that I do have my work cut out for me. So let's see what I can do with it, let's see what happens here. So I want to talk about the Declaration first. And there are two major themes in the Declaration that I want to pull out and highlight, and I want to keep coming back to and for us to keep in mind throughout the night. The first of those two themes is the theme that you probably all know the Declaration most for, that the Declaration is most famous for, and that's the theme of rights, right? The inalienable rights of life, liberty, and the pursuit of happiness. that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government shall become destructive of these ends, is the right of the people to alter or abolish it, and institute new government, laying its foundation upon such principles, organizing its power in such form as to them shall seem most likely to secure their safety and happiness. And I could go on, I could go on. I could go on, I want to stop there, but I could go on. Just as a side note, the Declaration, besides its whatever historical importance, political importance, its fame, I just personally think it is writing of the absolute highest literary quality. It's almost poetic. And so I would encourage everyone to read it. It's really just extraordinary. But I want to, instead of going on, I want to stop and highlight that last passage, right? It is the right of the people to alter, abolish, and institute new government, laying its foundation on principles, organizing its power and form, as to them, the people, right, shall seem most likely to secure the people's safety and happiness. What's the theme in that passage, right? What's behind that? It's the theme of democracy, right? The people are going to institute new government. They're going to establish it in a form that to them, the people, seem most likely to secure their safety and happiness. The theme of democracy. And not only was this a theme in the Declaration, this theme of democracy in the Declaration, but it was also happening at that time. There was democracy in action. It was in May of 1776, so remember about a month and a half before the Declaration in June 76, that John Adams introduces a resolution in the Second Continental Congress, and the Second Continental Congress passes, calling for all the colonies to write their own constitutions, right? To institute their own, institute new governments, right? In the form that they, the people in the colonies to be states, shall seem most likely to secure their safety and happiness. And that's what happened. All the states wrote their own constitutions right around the time of the Declaration. So not only do we have this theme in the Declaration of democracy, we actually have democracy in action in the state level. And then we also have democracy in action with our first constitution, right, in the late 1770s and early 1780s, with the Articles of Confederation, our first national constitution. And that was a very big, a very historic event. But it also caused some problems. Let me take a sip of this real quick. James Madison, who is the principal architect of our original Constitution, and the man history calls the father of the Constitution back then, right? Keep in mind, the Constitution we have now is very different than the one we have then. It's been amended 27 times in some very fundamental ways. But James Madison, the architect of the Constitution, he was diagnosing the problems that existed in the United States, in the colonies that then became states in the 1770s and in the 1780s under the Articles of Confederation. There were major problems. And one of my talks in Constitution Week some years ago really was about these problems in the 1780s. I'm not going to get into them because we have other stuff to get to. But there were very serious problems in the country. When James Madison was diagnosing those problems, one of the primary reasons that he came up with, if not the primary reason, was the excess of democracy. That there was actually too much democracy going on in the states at the state level and under the Articles of Confederation. And that was one of the most, if not the principal reason that Madison felt, and his supporters felt, that we had to revise and even replace the Articles of Confederation with a new constitution. An excess of democracy, think about that, right? We like democracy, but it was going too far. What was the problem with that democracy? What was the problem with that excess of democracy? Is that it was undermining rights. It was not sufficiently respecting people's rights. And this was the problem, right? Rights and democracy and rights, two major themes in the Declaration of Independence, two major themes that were actually playing out at the government, law and government level in the 1770s and 1780s. And there are two things. We like democracy, right? We like rights, but sometimes they're in conflict. Sometimes they're in tension. And that's what I want to keep in mind as we move through some of these remarks tonight. Okay, democracy and rights, rights and democracy, sometimes in conflict, sometimes in tension. Okay, so that's the Declaration. Put that to the side right now. All right, 1 out of 3 out of the way. All right, we're moving around here, moving along. Okay, but before moving on, I just want to make a quick apology to anyone who came out here tonight if you were only hoping to hear about, or mostly hearing about, the Killdozer. I can just see the disappointment in everyone's faces. Wasted my whole night on this. We're going to talk about that. But we're going to talk about some bigger themes, some more important themes like rights and democracy and such, how that ties into the Constitution. And I do have to say, even though I'm apologizing for that, I do have to say that you were forewarned, because I did have a subtitle to this speech tonight, which was Killdozer and the Constitution. I purposely made this subtitle long and boring sounding so that I had a defense. That subtitle is Zoning, Property Rights, and the History of Land Use Law in the U.S. Supreme Court, right? What a snoozer compared to the dozer. But you can't say you were not forewarned. So we're going to talk about some of them. I apologize if you were here for that. So I also do want to mention just one other item of how I got to why I'm speaking about this topic. Over the last handful of years in my own law practice, I've been doing a lot more land use law and municipal law. Zoning is a big part of my practice, and I'm also be teaching land use law, as Katie mentioned, at the University of Wyoming Law School next academic year. And so this area of law and policy of law and government has been on my mind. And I knew that in some unclear way that this had something to do with the Killdozer, right? That zoning and land use and municipal decision making had something to do with land use law. And so I wanted to look more into it. And so I did. So I looked more and I said, wow, there's a lot here. There's a lot here just on that side of things. And so here we are with the Killdozer and the Constitution. For those who might not remember or might not recall, and of course for all of our millions of people around the globe who are tuning into this just can't miss stuff tonight, the Killdozer was an event up here where a local Grand Lake resident and Granby businessman, Marvin Heemeyer, over the course of a decade or more, was involved in disputes over zoning and land use with his neighbors. We're going to talk more about this with his neighbors and with the town of Granby. Eventually, that dispute got to reach such a point, and what we're going to talk about it was playing out in town meetings, in planning commission meetings, in district court. But eventually, it got to such a point that Heemeyer fortified a D355A Komatsu bulldozer with concrete and steel. From what I hear, he was a master welder. And on June 4th, 2004, he went and he bulldozed a number of buildings in the town of Granby. Municipal buildings, commercial buildings, residential buildings. He also fired off a number of high caliber rounds from the dozer at a number of targets, thankfully not hitting any. And that lasted for a little over 2 hours before the dozer started to overheat. One of the tracks got caught in a half basement room in the old Gambles building, and the dozer was stuck. Heemeyer eventually took his life inside the dozer, and after about a little over 2 hours, that event came to an end. This was major headline news all over, not just in Grand County, not just in Colorado, not just regionally, not even just nationally, but international headlines on this incident, coverage from everywhere. That lasted for about a day, right? Day or two. And that only lasted for a day or two because on June 5th, 2004, the next day, Ronald Reagan passed away. And so all those national headlines, international headlines kind of shifted away from Granby. But there's a lot of people here that know how important this event was in our local history. There's a lot of people here who were there that day. There are a lot of people here who knew some of the people involved. And so it's still a very important event in our location, even at this point, over 20 years later. Okay, so what was going on here? What was going on with this Killdozer incident? Well, the dispute that was happening between Heemeyer, his neighbors, the Dochiffs that owned the Granby Industrial LLC, and the town of Granby, whatever that dispute originated from, right? There's stories there, there's different points of view where it came from. Whatever the dispute might have been, it was interpersonal, or there were grudges, or things were said, or whatever it was, I'm not that interested in. What I'm interested in is that the dispute played out within the context of zoning battles, land use law, and municipal decision making. And by the way, we keep coming back to this, but what is municipal decision making, right? The people of, let's say in this case, Granby, they vote, they elect their local representatives. Those local representatives, they make decisions based on a majority vote. That is democracy in action, right? And in America, there are fewer examples of pure democracy than something like a small town municipal government, right? That's democracy in action. And those decisions have very important consequences for what people can or cannot do with things like property or things like business, right? Their rights, right? So you have these themes, democracy and rights, that are playing out here. And that's what was happening. You know, that's the background of what was going on with these zoning and land use battles. So I'm gonna keep sipping on this because it's very delicious. I don't know if anyone else has a cocktail out there. It's, you know, we're celebrating the Constitution. You guys celebrate the right way. Okay, so what was happening? Well, here's a little bit of background. I'm trying to do this as uncontroversially as possible, and using primary records. All right, I have some things I'm going to hold up in the course of this: court decisions, ordinances, resolutions. What was happening is Mark bought this property in 1992 at an FDIC auction. Eventually, he opens a muffler shop there that, from what I hear, was fairly successful, if not very successful. Now, some years into this, his neighbors, Granby Industrial, were operating a concrete plant, a concrete operation. They wanted to expand this concrete operation by building a concrete batch plant. And so they acquired some property near where they were for this expansion. They also inquired into buying Marv Heemeyer's property to build their batch plant. They had some indications from the town of Granby that the town of Granby would only approve this expansion, this new concrete plant, if it could include Marv's property to give some more of a buffer to some of the other properties there. So they approached Marv to buy his property, but no deal was struck. All right, there's different stories back there too. I don't want to get too much into the details, but no deal was struck. So the main issue at this point, let me make sure I'm not forgetting anything here, right? The main issue at this point is that the land that Granby Industrial was operating on was zoned a highway and general business district in Granby. And that zone did not allow for concrete batch plants. You could go check this zone out, by the way. I was just in chapter 16.9 of the Granby Town Code. Still there, highway general business. Concrete batch plant operations are not allowed. They're only allowed in the industrial zone, and even then they are only allowed by special use permit, not by right. Okay, so this was the main issue. They wanted to build a concrete plant. It was not allowed in the zone that they were, where their land was. So they approached the town with a rezoning request. And this rezoning request was to change the zoning of their parcels to what's called a planned development overlay district. And some of you might have, if you ever deal with land use stuff, might have heard this kind of thing more commonly referred to as a planned unit development. This comes from a Colorado statute, 1972, enabling localities to pass these rezonings for planned unit developments. Same kind of thing. This is the overlay district that Granby was doing. And the whole idea with the overlay district is it allowed more flexibility, right? Zoning and highway and general business district, not allowed. But if you rezone into an overlay district, then you could allow something like this, maybe with some special conditions, maybe with some special concerns addressed. And so that's what they did. They approached the town to rezone their parcels so they could build that concrete batch plant without needing Heemeyer's property. Zoning, interesting, right? Interesting that we even have zoning, right? And I'm gonna come back to this, but I want us to be thinking about this. Like, what is zoning, right? It's just a local municipality, local little old town, right? Little old Grand Lake, little old Granby municipality with its democracy in action decision-making can say, land over here can be used for this, but it can't be used for that. Land over there can be used for this, can't be used for that. Privately owned land, right? Land over here, that's zoned for commercial, you can't do industrial, can't do residential. Isn't that interesting, right? Isn't that a powerful thing? And that's just decisions made at the municipal level, right? That's democracy in action, impacting what? Impacting property rights, property and liberty rights, right? Democracy and rights, right? Democracy and rights are all in play here. So they approached the town with this rezoning request. Heemeyer opposes it vehemently, okay? He rallies the community in and around Granby, in and around this area to oppose it as well. saying there's going to be all sorts of problems. There's going to be pollution, there's going to be traffic, there's going to be dust, there's going to be noise, it's going to be bad for the community, bad for surrounding properties, all these problems. And guess what? A lot of people agreed. And there was a lot of opposition at first, and the town at first did not approve the rezoning request. They did not approve it because there was this opposition, there was these legitimate concerns. And they said, go back and revise the plan and address some of these concerns. We're not going to approve it as it is. So that's what Granby Industrial did. They revised their plan. They go and resubmitted it to the town to rezone that property to allow for the concrete batch plan under the overlay district zoning. And this time, there was a lot less opposition. One account has Keymeyer and his lawyer as the only people there opposing this request. But whatever the case is, a lot less opposition, right? The idea behind that, or the theory behind that, is that a lot of the concerns that were behind and motivated the opposition initially were addressed in the revised plan, and so there were a lot of there's a lot less opposition at this planning commission. I wasn't there. I don't know. I don't know exactly, but that there was whatever the case was, a lot less opposition, and the revised plan addressed some of these concerns, and the town then approved the rezoning of the Granby Industrial, the parcels where Granby Industrial were operating. Now I want to read. I mentioned I have some primary sources here. I just want to read a couple quick things. I'm not going to be reading a lot during a speech. Bad move, to do that. But I have here the ordinance from 2001. This is the ordinance passed by the town of Granby approving the overlay district to allow for the concrete plant. And what does it say? Okay, I'm just going to read a couple things from it. It says that the rezoning request for the concrete batch plant would promote good design, increase efficiency in public and private services. It will allow greater flexibility and innovations in development. It was a unique and truly innovative project. It would improve commercial and industrial facilities, lessen the burden of traffic, conserve the value of land, that it was compatible with the Granby master plan, and that it was compatible with some of the properties surrounding it. And it pointed out specifically to the gravel pit. I don't know if some of you know the Granby area, to the gravel pit there, and then two adjoining properties that were actually that had industrial zone operations going on. So those are the findings by the town. Okay, but the town, in their approval, making those findings, also put some conditions on the approval, additionally addressing some of the concerns on the things that we mentioned, traffic, dust, etc. What were those conditions? Only a few. Just hang with me. Right? One of them had to deal with access and traffic, right? That only the roadway from the batch plant connecting directly to County Road 612 and proceeding from there to US Highway 34 could be used. So limiting, restricting, addressing concerns about traffic accessibility. The other condition was that there had to be a revegetation of the parcel, right? Just addressing some concerns from the construction and operation. And the revegetation shall comply as a minimum with USDA Natural Resource Conservation Service standards, or whatever the hell those are, but something that they had to comply with. And the last addressed dust specifically, saying that had to be paved, right? The parcel had to be paved, and then after paving was completed, dust control shall be accomplished by street sweeping and the application of water. Findings of the town of Granby, conditions put on their approval. There you have it, right from the horse's mouth. Now Marv didn't agree with this, all right? Marv almost point by point says, I don't think it's going to be good for the community. I don't think it's going to be good for property values. I think it's going to increase traffic. I think it's going to increase dust and pollution and all these problems. And he put a letter in the Sky High right around that time. Patrick's here, can attest to this. That almost point by point addressing some of these findings, or addressing some of the findings which address actual language in the ordinance, saying that he disagrees with all this. Not surprising. Now, Patrick is here, by the way, who wrote the Killdozer book, which is available for purchase and signed by the author here on the table if anyone's interested. One of the central theses of Patrick's book is that why was Marv opposing this? Did he really think it was bad for the community, or was he really concerned about dust and pollution and noise and traffic and whatever? Or was it that if the rezoning request was denied, then the only opportunity for Granby Industrial to build their batch plant would be that they have to buy Marv's property, in which case he could sell it as a premium. That's essentially that's the the thesis of the book, it makes perfect economic sense, right? Whether there was other things going on or not, I don't know, but it certainly does make rational economic self-interest sense. Whatever the case is, the approval went through. Marv went ahead and sued the town of Granby and sued Granby Industrial. And what did he say? He said three major things. The first was that there were procedural errors in the approval process. The second was that there were formality errors in the documentation of the approval. And the third was that this was not a unique and innovative project. And using that language is specific. It's in the ordinance. It was one of the findings of the town, that it was not a unique and innovative project. What did the district, those are the three claims. What did the district court say? By the way, here's the district court opinion, if anyone's interested in, from 2002, Judge Richard Doucette. And it's a pretty good, beefy decision for, as far as district court decisions go. Lays out a lot of factual background, a lot of procedural background, analyzes the language in the ordinance, and applies it to the facts in this case. It analyzes some of the other Colorado statutory and common law, applies it to the facts of this case. And he dismisses the technicality claims, right? The procedural claim and the formality of the documentation claim just doesn't find that it was an error or had any impact on this process when you look at the language of the ordinance and apply it to what actually happened. But the third was interesting, right? Because the third claim was that this is not a unique and innovative project, and for a municipality to approve a rezoning, it is, under the ordinance, required to be unique and innovative. So what does the court say? What does Judge Doucette say? I'm going to read his written words. Okay? He says that the town of Granby has found this application to rezone is in conformance with the zoning ordinance and that it involves a unique and innovative development. That finding will not be disturbed on appeal by this court because there is some evidence in the record to support the finding of Granby. Okay, that's the real meat of this opinion. And what the court is doing there is not saying that the court has reviewed whether this is unique and innovative, and we think it is unique and innovative, therefore it's allowed. What the court is saying is that we're going to defer to the decision-making of the town. We are going to defer to the decision-making of the town because there is some evidence in the record to support the town's decision. We're going to give them the benefit of the doubt, and we're not able to say that this was arbitrary and capricious and completely unreasonable, so we're going to defer to the decision of the town. And this is a very important standard of review. Rick, this is rational basis scrutiny, what we call it. A low level of review. And it's very important to keep this in mind because it's generally true, there's exceptions in certain circumstances, generally true when it comes to zoning and land use and municipal decision making, that courts, and this is not just the district court, right? This is Colorado Supreme Court, this is the federal judiciary going up to the US Supreme Court, will generally defer to the decision making of the municipality as long as it is not arbitrary, capricious, unreasonable, as long as there's some evidence in the record that will allow, that makes it rational for that locality to make that decision, the court will uphold it. They're not going to substitute their own opinion. The court is not going to substitute its own opinion for the decision of the municipality. Now think about that. In this case, right, we have what I keep saying municipality, right? But every time I say municipality, I want us thinking democracy in action, because that's all that is, right? The people of Granby vote, they elect the representatives, those representatives make decisions based on majority vote. That is democracy in action, and those votes have very, very, very real consequences on property, and what you can and what you cannot do with your property, what you can and cannot do with your business. Very serious and real important consequences on rights, right? Rights and democracy. Democracy and rights, and courts will defer to those decisions of democracy in action when it comes to zoning and land use law specifically. And there's also other areas where they tend to defer. Maybe my talk next year will be about the levels of scrutiny. You know, so you got rational basis, intermediate, strict. There's all sorts of different good stuff there in the constitutional law context. But all you need to keep in mind is that the courts will defer. Right? They will defer. The presumption is that it's presumed valid, those decisions, unless challenger proves otherwise. Okay, so let's see where we're going here. That decision was handed down in April of 2002. Now I want to round out just some of the Killdozer stuff here, because as some of you might remember, or might be thinking, there was also this sewer and water issue going on at the same time. Okay, so what was going on there? And this is less important, less squarely on point for the constitutional issues that I'm going to get to, I promise. The Constitution, we haven't even like really talked about that yet. Let's go here. Let's get to the good stuff. But what happens with the sewer stuff is Marv was operating a septic tank on his property. That was ruled to be out of compliance with the Granby Water and Sanitation District requirements. There's all sorts of history there and all sorts of points of view there about what happened with the annexation of that parcel, whether who should have been required to pay for the connection to the sewer main and the lift station, whether there should have been a requirement to have utility easement over neighboring properties to get to the sewer main. There was almost deal made between Granby Industrial and Marv where they would grant him a utility easement to easily connect to the sewer main if he dropped his lawsuit against them and the town. And then there were also questions about the enforcement, the timing of the enforcement. It was right around this time. Now, when there was a finding of non-compliance, there was also a lot of time to allow for that property and the sewer system to be brought into compliance, but it never was. And eventually Marv was fined for this. He was fined, and eventually he did pay. But this sewer issue really was a fuel on this zoning and land use fire. He did eventually pay, but at that point, the die had been cast. Take a dramatic sip of my, I'm not gonna tell you what it is. So Marv does sell the property for $400,000 in late 2003. He leases back a little warehouse space on the property, and that is where he builds the dozer, and on June 4th, 2004, goes and does its thing. Now, that's usually the point of the story where like everyone gets interested and everyone wants to hear about and learn about and talk about and all that stuff, but that's the point of the story where I'm mostly gonna stop. You can go read the books, you could go watch the documentaries. There's plenty of stuff out there if you wanna, if you wanna look at that kind of stuff. But Marv interestingly left tapes, he left recordings, and he left other documents about why he did this, and about this whole saga, right, from his point of view. And what does he say? Well, he says a lot of things, but one of the things he says is one of the primary reasons, if not the primary reason why he did this, was that he was avenging wrongs done to him, that he felt was done to him by the town of Granby, by the municipality, democracy and action decision making, and how that was intertwined with Granby Industrial. Right? He felt that the municipality, the democracy and action were making decisions that he felt wronged him and his liberty and his property rights. Right? It's democracy and rights. It was rights and democracy that were really behind what motivated, at least in his own words, one of the principal, if not the principal reason that motivated him to do all this. Right? Rights and democracy, avenging the decision-making municipality against what he felt were his property and liberty rights. Same themes we pulled out of the Declaration, right? Just a few minutes ago. The same themes that were at play at the time of the Declaration, where the states were instituting their own governments. When we wrote the Articles of Confederation, where we placed the Articles of Confederation and ordained and established the Constitution that we have today. Democracy and rights, rights and democracy, right? Sometimes they're in conflict here. Sometimes they're in tension. And they really form the background of this saga, the Killdozer saga, what was really going on in that dispute of land use and zoning. So you might be thinking that, okay, there must be something going on with the Constitution here if this is so fundamental, these grand themes of democracy and rights dating back to the origin, right? There must be something going on. And after all, it's Constitution Week, right? There has to be something going on here with the Constitution. What is going on with the Constitution here that has to do with this? Well, there are two specific clauses in the Constitution that directly address these themes of democracy and rights and the conflict and tension between them. Specific ones that I want to pull out. The first is the Due Process Clause of the 14th Amendment, which says that no state and through the state's municipalities, right? No state shall deprive any person of life, liberty, or property without the due process of law. Due process clause of the 14th Amendment. The other one is the takings clause of the 5th Amendment, which says that nor shall any person be deprived of property for public use without just compensation. This is the takings clause of the 5th Amendment of the U.S. Constitution. Okay, so one of these things, we can recite some more passages from the Declaration and the Constitution, all that. I'll have fun doing that. So what do these two passages have to do with? Well, interestingly enough, who else but the U.S. Supreme Court has one of its all-time landmark historic decisions handed down in 1926, dealing with zoning, with the question of the constitutionality of zoning under the Due Process Clause of the 14th Amendment. And what was the issue there, right? What was the issue? Now, it's hard for us to sometimes imagine this because zoning is everywhere now, right? It's just everywhere. We take it for granted. But that was not always the case. Zoning was not around at all until the early 1900s, and largely in a response to industrialization that was really hitting its stride in the early 1900s, causing lots of issues with safety, security, with urban crowding, with sanitation. And as a response to that, localities began to zone. And they began to say, okay, factories, right, early industrialization era factories, that's okay, but there's a lot of dangerous activity, dangerous equipment, there's a lot of noise and whatever, dust, pollution, whatever's going on. So we're gonna put you over there. You're only allowed to operate in this area of the city, or this area of the locality. Okay, commercial, same thing. It's busy, there's businesses, there's people coming and going, you don't know who those people are, there's traffic, there's noise, there's all this stuff. Commercial, we're gonna keep that here, we're gonna keep it away from the industrial, and we're gonna keep it away from the residential. Because in the residential, we have families, right? This is where we're raising our kids, this is where we're sleeping at night. So we wanna keep that away from those dangerous activities and all the hustle and bustle of industrial and the commercial zone. And it doesn't matter who owns that land, right? It doesn't matter exactly what you're doing, but if it's industrial use, you can do it, you're allowed to do it there, you can't do it there. Commercial use, you're allowed to do it there, you're not allowed to do it there and there. Right? Residential, you're allowed to do it here, not there and there. So this was interesting, right? This is a lot of authority for a local municipality, a local democracy in action to make these decisions over what can happen over property and property rights, democracy and property, democracy and rights, right? Keep coming back to it. So what happened in this landmark case? The case is called Euclid versus Ambler. It was handed down in 1926. And so, we're celebrating the 250th anniversary of the Declaration that's going to hit its moment on July 4th, 2026. We're also celebrating the 100th anniversary of Euclid versus Ambler, which will be hitting its 100th anniversary later this year. Well, at least I'm celebrating it. I'm probably the only one. But it's a very historic decision. So, and that's not supporting or not supporting Malcolm, just because of its historic landmark status. I'm celebrating the 100th anniversary. So what happened in here? Well, in Euclid. Well, what happened was that when this zoning came about to address some of these very real problems with industrialization, right? Zoning did good things, right? We didn't want our kids playing in the street next to some factory with dangerous stuff, right? Zoning is not necessarily a good thing, or it's not necessarily a bad thing, right? It's how you use it, it's what you do with it. It has been used for good things, it has been used for bad things. And the same thing with democracy in action, right? It has produced good outcomes, it produced bad outcomes. The same thing with rights, right? It's defending that, sometimes good outcomes, sometimes bad outcomes, right? All these things, all these themes, all these activities, they can be good, they can be bad. It depends how they're used, right? It depends on the context. So, the opponents of zoning were intense about their opposition. They literally called it communism. They were so intense about this new form of land use control that they thought it was communistic. And I have a couple quotes that I wanted to read from the briefs to the Supreme Court in the case of Euclid versus Ambler, because I think they reflect how intense it's hard to imagine. It's almost funny to us now because zoning is so accepted, it's everywhere, we just take it for granted. But that was not always the case. So this is just a couple real quick quotes from the brief of the plaintiff to the U.S. Supreme Court in Euclid versus Ambler in 1926. It said that zoning is nothing more than a desire of some people to tell other people how to use their property. Right? This next one's very, very colorful. It said, if the right of private property is subject to the unrestrained caprice of village councils, municipal government, municipal democracy in action, right? The right of private property is subject to unrestrained caprice of village councils, and the courts can do nothing more than retire behind a conclusive presumption of soundness. That's that deference I was talking about, just deferring to the decision-making in the town, a presumption that it's valid, right? A presumption of soundness. Then obviously we have outgrown the civilization established by the Constitution and have surrendered private ownership of property into a sort of communistic ownership and control upon which an entirely new order of both economic and social organization will be based. Okay, maybe a little hyperbolic, but that is not unrepresentative of the intensity of the opposition to zoning when zoning first hit the scene. And it made its way all the way to the Supreme Court. And this is, by the way, this is such a landmark historic case, Euclid versus Ambler. This entire, you see I have my pocket constitution. This entire book is just about this one case. There are very few cases in Supreme Court history that have just, where the book talks nothing about except that one case. There's very few, maybe Brown versus Ward, maybe Dred Scott, maybe Roe, maybe Marbury Madison. But very few in the history. Euclid versus Ambler is one of them. So, okay, so what happens in this case? What are some of the facts here? I'm going to run through it somewhat quickly. The village of Euclid, right, it's called the village of Euclid, is a suburb of Cleveland. It enacted these zoning rules where it segregated industrial use, residential use, commercial use. Some more complexity there, that was the basic idea. Ambler Realty Company owned some property. They wanted to use it for industrial use or sell or market it as industrial use, and they were not allowed to, so they sued the town, saying that zoning is unconstitutional, that it is the state, through the state municipality, depriving them of, not life, but liberty and property without the due process of law. They said that zoning is unconstitutional under the due process clause of the 14th Amendment. And guess what? They won in the federal district court. They won. The federal court said this is unconstitutional. It is a violation of the 14th Amendment, but it was appealed. It went all the way up to the Supreme Court. And the Supreme Court, three Supreme Court justices agreed and said this is unconstitutional. It is a violation of the 14th Amendment, the due process clause of the 14th Amendment. But three is not enough, right? The most important rule, what's the most important rule at the Supreme Court? The most important rule of the Supreme Court, the rule of 5. Right? You need 5 votes. You need 5 votes. So they only had 3 for the unconstitutionality, which means that the 6 justices thought it was constitutional. Justice George Sutherland wrote the opinion, and he said that zoning is not unconstitutional. It is a valid exercise of what we call the police powers of the states, through the states and municipalities. And this police powers is important terminology. It means more than just badges and guns and cops. It means the authority of states and localities to pass laws, regulations, ordinances, resolutions that promote the public health, safety, and general welfare. You may have heard some of these terms thrown about out there. It's really just another way of saying democracy in action, right? The police power is reserved to the states and through the states' municipalities to enact laws to regulate activity, to regulate property and liberty rights, in the pursuit and the promotion of public health, safety, and welfare. And Judge Sutherland and 5 other justices that signed on to that opinion said that zoning is a valid exercise of that police power. And why does it promote, or how does it approach, how does it promote the public health, safety, and welfare? Well, the court laid out a few points. The court said that by segregating these uses and some of these dangerous uses from some of these more residential uses, it helps with fire protection in the community. It helps, and I have some written down so I didn't forget. It helps the safety and security of home life, right? It helps prevent street accidents, and it's safer for kids. It reduces traffic, it reduces noise, and it's better for family life and for raising kids. But the court didn't come to those conclusions on itself. What they said was that there's enough evidence in the record that the village of Euclid, that little municipality, democracy in action, could make that decision. Right? There's enough, we're going to defer to the decision-making of the village of Euclid. So there's enough evidence where it's not unreasonable, it's not arbitrary and capricious for them to think that zoning advances the police powers by making these protections. Same exact standard of judicial review that Judge Doucette used in the 14th District Court here in Hot Sulphur Springs when he was ruling on the Killdozer saga. Okay, it's the same judicial standard of review. So a valid exercise of the police powers, a valid exercise of that democracy in action, regulating property rights. Okay, rights and democracy, democracy and rights. The same themes in the Declaration, the same themes at the heart of the dispute behind the Killdozer saga. It's the same themes that were in Judge Doucette's opinion, the same judicial review standard. It's the precedent that allows for zoning. It's the reason why we have zoning in America. It's the reason why Granby has the Highway and General Business District. It's the reason that they have the Overlay District. It's the reason that the Village of Euclid has zoning. It's the same judicial precedent for that standard of review to defer to the municipal democracy in action, regulating rights. Rights and democracy. Democracy and rights. Interesting, right? I hope you think it's interesting. That could have been a pretty good place to stop, but the law school teacher in me has to continue and mention some other items here. So this is kind of like the classroom portion of the night, and there'll be an easy quiz at the end. Well, if you're not into that kind of thing, just consider this free legal advice, which everyone seems to love. So I also mentioned the takings clause of the Fifth Amendment. Nor shall private property be taken for public use without just compensation. So what does that mean? Some of you may have heard of the term eminent domain. It means that government can take land, private land, for a public use, it just has to pay fair market value, right? Just compensation. So probably one of the most classic examples of this in our American history is the interstate highway system. It took a lot of land, a lot of private land to build that. It was for the public use. The highway system was public use. And that's perfectly allowed under the takings clause, except it has to be paid for, right? And justly paid for. So it can't be at a discount, right? Just compensation, fair market value. So that's allowed. But what happens if government doesn't take your property, but does some other things to impact it in important ways? These are often called inverse condemnation causes of action, and what that means is that through just regulations, government can take your property to where they owe you money. They owe you just compensation. The classic example of that is when there's some physical occupation of your property. That's a per se taking. Government owes you money. It has to be for a public use, right? And as long as it is, that's a per se taking. They owe you money. The other one is a regulatory or a regulation that impacts the value of your land to such an extent that there is no economic viable use of your land, right? The regulation completely eliminates the economic viability or value of your land. That's a per se taking. You're owed money. Okay, and there's a lot that goes into this, by the way. There's a whole history. Euclid really kicks this off in 1926. There's other cases about this stuff around that time and that have developed over the last 100 years. We could talk some more about that if you want during Q&A. I'm sure you're all just on the edge of your seats about it. But I'm just giving you some of the basics. The other one that I want to mention too that's very interesting is on exactions. What the Supreme Court has said about exactions or permitting conditions under the Fifth Amendment Takings Clause. And what the Supreme Court has said is that if you want to do a development on your land, that's okay. And the government can even require you to dedicate land, an easement usually, in return for that approval for some kind of development. They can also say, that, okay, you're going to do that development, but you owe us money. You owe us impact fees, right? That development is going to cause some kind of burden on public services, and you need to pay for that. Also perfectly allowed. The only condition, not the only, but the most important conditions is that those requirements saying you can use your land the way you want to for that development, but you have to give us land and or money. The two requirements are that the dedication, the exaction, right, that requirement of giving land or money has to be related to an impact from the development, and that it has to be roughly proportional to the impact of the development. If it's not, they can't do it. Okay, it's interesting, some interesting case law. This is more recent, 90s, 80s and 90s, and then also some fleshing out of it as recently as in the 2020s here. But that's the basic idea, right? So taking law is very interesting, right? Government is allowed to take your land for public use, right? You want the interstate highway system, they have to pay just compensation, but also if they regulate your property too much, they can also owe you money. Now, those words, they can go, the regulations can go too far. That's an actual quote from one of our all-time legendary Supreme Court justices, Oliver Wendell Holmes, Pennsylvania Colby Mahan, 1922. I'm pointing to Rick, maybe you recognize the citation. But he says regulations can go too far. As I mentioned, if it's a physical occupation or if it is if it's a full economic loss, per se taking to owe you money. What if it's not a full economic loss? Then it's analyzed under a three-part test that comes out of a case of Penn Central in the 1970s. Really getting technical here in the law school realm of things. I'm going to wrap this up in just a minute. But that says that the court will analyze those regulations to decide whether the government can do that or whether the government owes you money. That those factors are the severity of the regulation, the character and nature of the government regulation, and how it impacts the private property owner's investment-backed expectations. They'll run that analysis. If it comes out in favor one way or the other, then it's either allowed or not allowed, money's due or money's not due. Seeing some eyes glaze over here as we get into the technicalities of the law. Come on, this is the good stuff right here. And what I hope is coming, what you're thinking is that I'm talking about Supreme Court history. I'm talking about constitutional law and history, constitutional history. But these are decisions that impact each and every one of our lives, each and every one of our pieces of property, what we can and what we cannot do with our property, what we can and cannot do with our businesses. And so it has a very real, very close connection to our everyday lives. Right? It happened with the Killdozer saga. This is just a muffler shop and a concrete plant they want to operate. It's a dispute. It goes to the planning commission, the town board. It goes to local district court, and it ends in the bulldozing of the town. Right? These are things that are everywhere. Right? Every jurisdiction in America is making these democracy in action decisions almost every single day that impact rights and liberty and property rights in very important ways. And it's all happening within this context of these constitutional law cases coming down from the Supreme Court, and even broader, following these grand themes of democracy and rights and democracy, right? These two themes are often in conflict, often in tension. And a lot of our history, a lot of our American constitutional government policy and law history is how these tensions between democracy and action decision-making and private and liberty rights, private property and liberty rights interact, where to draw the line between them. Because there's not one wrong answer or one right answer and one wrong answer, right? It depends on what needs to be done. It depends on what kind of harm is trying to be alleviated. But it is behind so much. I'm tempted to say everything, but that could be easily disproven. It is behind so much of what happens in American law and government. From the beginning, the Declaration to the Articles of Confederation, the Constitution, the 14th Amendment, the 5th Amendment, every single jurisdiction, every planning commission, every town board, city council, county commissioners, and it's at the heart of the dispute in the Killdozer saga. Democracy and rights, rights and democracy. Interesting, right? Do a little cheers to that real quick as I kind of wrap up here. Do a little cheers. Okay, so I'm going to wrap this up by bringing these topics up to some current event stuff. And why I want to do this is that I think you're all going to, if you haven't already, hear more about some of these issues, these public policy issues at all levels of government, local, state, and federal. They are, front page public policy issues, and they're happening very actively right now. And these are all playing out in the context of zoning and land use, which of course are just examples of these themes of democracy and rights and how that interplay works. And what are some of those public policy issues? The primary one I want to mention, that I think everyone knows about, is housing, right? And the affordability and availability of housing. There's a housing crisis it's been called a lot of times, all across the country, right? We deal with it here in Grand Lake in certain ways, but it's happening in cities, it's happening in urban areas, rural areas, suburban areas, in the mountains, in the plains, right? In the coasts, the heartland. Housing is a problem. The cost of housing is a problem. And you have a lot of activity at all levels trying to deal with this problem by reforming zoning and land use laws, is reforming what municipal democracy in action decision-making can do over property rights. Just last legislative session last year in Colorado, they passed 6 separate pieces of legislation that impacted this exact thing. Dealing with density, dealing with parking requirements, dealing with rights of first refusal for local governments to purchase certain pieces of parcel for affordable housing reasons. And it is a topic that has really taken off recently in public policy circles at all levels. Some of you may have heard it as the abundance agenda. Where is it? Okay, Avis knows, right? The abundance agenda has become a popular moniker in a lot of public policy circles to address the housing concern, produce some supply side solutions to the housing problem, which means, right, reducing some of the restrictions on how land can be used and how land can be zoned. And instead of just, single family dwellings detached with minimum lot sizes, well, maybe we can allow duplexes or triplexes or apartment buildings. Or maybe we can allow more than 5 stories, 10 stories, right? Supply side solutions to housing problems. And these public policy discussions and these reforms are also bringing together a very, very interesting coalition, partisan ideological coalition. Because you have certain people and groups that tend to be more libertarian or maybe more conservative, more right, libertarian kind of oriented, that says, no, government should not have any say in what I do with my land. And then you have certain more progressive groups, progressive people that are more exclusionary zoning is discriminatory, right? It's snob zoning, it's NIMBYism, right? Not in my backyard. We don't want those people moving into our neighborhood, right? There's people that oppose that kind of approach to municipal law, municipal decision making and zoning and land use decisions that have all coalesced together from the right and left to pursue this abundance agenda, pursue some of these supply side solutions to the housing problem. It's also true for energy, for the building of energy infrastructure, new energy, additional energy, sustainable energy, whatever kind of energy. What is happening a lot is that energy infrastructure can't be built because it's not allowed in that zone, or it has to go through a special use permit and it's not being allowed, whatever the case might be. So you'll see a lot of energy infrastructure. You also see this irony of where environmental laws that were passed in the 1970s that did a lot of good things to protect our air and protect our water are actually being used now to stop new and more safe, sustainable energy projects. Kind of an irony, right? But it's with people who don't want certain development in their neighborhood or in their backyard. And you also see in transportation infrastructure. All this stuff is playing out. These are all problems across the country, but that play out at local, state, and also the federal level. And it all has to do with these issues of zoning and land use, right? One of the great examples, zoning and land use, municipal decision making, one of the great examples of these grand themes of democracy and rights, and how that conversation, how that debate happens, how we draw that line. What can democracy in action do? How far can they go? What can they say about private property rights, private liberty rights, business rights, etc.? 2 grand themes. Now, hopefully you have seen how it connects to some of these more historic themes, right, that we pulled out of the Declaration, that were happening back at our origins, that are embedded in our Constitution, that form the background, the meat and potatoes of some of the most historic landmark Supreme Court cases in our history, and that also form the background or the context of the whole Killdozer saga. Hopefully you'll understand some more about after tonight. And then also when you go out there and I can promise you haven't already, you're gonna hear more about some of these housing, energy, transportation issues at every level of government, local, state, and federal. Hopefully now when you do, you kind of have a better understanding of where some of that stuff has come from, or what's behind some of that stuff, what are some of the major themes that are playing out, and maybe it could help form some opinions or form some of your own decision making when it comes to these policy issues, these law and government issues, these democracy and rights issues. And so with that, I'm going to wrap up, and I will invite questions, if anyone has any, out here about anything you want. I think that was about good timing. I covered. Okay, gentleman here on the left. My left.
The stories that you've
Yeah, so the question is that some of the stories I've been telling, it seems that the municipalities seem to win out over property rights. How does that work, right? Or how does that... Which has more, right? And so that's the ultimate question, right? That's the ultimate question that plays out almost every single day in every jurisdiction. Now, there are certain lines that just can't be crossed and won't be crossed. One of them has to do with things like also the equal protection clause that I didn't talk about because I had to limit to some extent, right? You can't discriminate local decision making based on irrational differences between groups or between, say, applicants, right? It has to make some sense. There has to be some rational basis for it. That's a check on some of those. Some of the Supreme Court cases that I mentioned are checks on this. You'll see, I think we have some municipal staff in the House tonight. I see, there's Brian, we got some, I don't know, call him now, but former mayor, town manager was here earlier. A lot of what they do will say, okay, well, we're gonna impose a fee on some, say, permit application. But that fee, it has to be tied to the actual impact of of the development or what the permit is asking for, right? So the municipality doesn't win out there, right? It balances the two. The same thing that whatever they're asking for, whether it's a fee or whether it's a dedication of land through an easement, whatever it is, has to be related. These are checks that come from the Supreme Court, cases that I was just talking about, that have to deal with this question of what wins out, municipality or property rights. But the question you ask is kind of like the point of all this, right? Which is that these questions are being asked and being answered everywhere around the country, in every jurisdiction. And sometimes you don't know exactly what the outcome is. But what I will tell you is that at the local level, right, so say local district court or state appellate court, or the Colorado Supreme Court, the federal judiciary, the US Supreme Court, it is very, very difficult for someone who is on the losing end of a municipal decision to overturn that decision in court because of that deferential standard of review. Is very difficult. I see it in my practice sometimes, and sometimes that's good, right? Well, if General Motors is dumping pollution into our lake and the municipality finds them or doesn't let them do that or makes them move, we want a democracy in action to win in that case, right? But there are other times where maybe it's not, right? Maybe there's some reason, some prejudicial reason that they're hiding behind, well, this is for the public interest, health, safety, and welfare, that they're making these decisions that make it come out the other way. It's not necessarily a right or wrong, but I will tell you, it's very difficult to win those challenges. You normally don't see them happen because it is presumed valid, and it's the challenger, the plaintiff's burden to overcome that presumption. Very difficult thing to do. And so a lot of times those challenges lose. Question here?
I'd like to know if, in this case of Martin Keymeyer and eminent domain, if they played a role, because you had two private entities, and then the municipality awarded one over the other. So how did eminent domain?
So the question is, how does eminent domain play into the zoning questions that were behind the Killdozer dispute, right? Eminent domain didn't play. So eminent domain, what that specifically refers to is when the government takes private property for a public use. That's not what happened here. But what happened here was that you have Keymeyer saying you should not rezone this neighboring property into a new zone that allows concrete plants. And you have those neighbors, Granby Industrial Limited, saying you should rezone this to allow the concrete batch plant because it's going to be good for the economics, it's going to be good for the town, and it's not going to cause these harms, and it's not a problem. And so the local planning commission makes their decision, they bump it up to the town board, and the town board makes their decision. Do we want to allow it? Do we not want to allow it? There's a lot of authority there, right? There's a lot of discretion there. The town decided, I read off some of their findings, they decided that we are going to allow it, that they did think it was good for the community, that they didn't think it was going to cause some of these harms, that some of the concerns that were brought up were either addressed or that were going to be the subject of the conditions on the approval. So that's what was playing out here, but you see how you have this interaction, right, of that democracy in action and private property rights. Question here, I'll kind of make my way over this way.
I've been in the business for about 42 years.
Been in the business of
Multifamily housing.
multifamily housing.
The taxes that the landlord has to pay on property are determined by the state. The state will not allow you to use your income derived from the property in establishing
Yes.
The state becomes the culprit.
Yes. Question there, or do you want me to just kind of reiterate your point?
No, go ahead.
Okay, so there was no question, but the point was making, this gentleman's been in the affordable housing or the housing development industry for many decades. And he makes a really good point, because taxation has a lot to do with the affordable housing supply side solution reform agenda. And what he's saying is that the tax rate of your private property will be at the same level, whether you are renting it out at very high prices or very low prices. And actually, I have seen this in that reform agenda, that some proposals to change that, so that if you are actually making a lot of money out of that property, you're going to be taxed at a rate that reflects that, which makes sense for affordable housing purposes, because there's less incentive, or there's some incentive to maybe not charge as more for renting in this case as opposed to buying. Yep, it's a good point. It's all part of this policy discussion that if you haven't seen it out there already, you will at every level of government. All right, in the back there, then we're making our way across.
Three points I'd like your opinion on.
3 points.
The Kilo decision, weren't they pushing, the municipality pushing a different agenda for acquiring that property? The fallout from it was the loss of freedom hotel, if you heard about that, and then the recent during the COVID year, if you were a landlord, the edicts coming out saying you don't get rent, but there was no compensation for the landlords doing it.
So 3 questions. One was about a very famous landmark Supreme Court case called Kilo versus the City of New London, 2005, dealing with eminent domain. Another one, the second point was something I'd never heard of, so I don't know about that. And the third one was about COVID charging rent restrictions. Kilo, I'll mention quickly because it's a landmark case, and it is a very controversial case. The Supreme Court handed down 5-4, 2005. It said that urban redevelopment, a decision by a local municipality, City of New London in Connecticut, the decision of that democracy in action, that this area of the city was blighted, was enough for the local municipality to take that land through eminent domain, pay them money for it, but to take it through eminent domain and have it go to a redeveloper for an urban redevelopment project. It's a very controversial case, 5-4. There were, I'm going to forget the exact number, but it's something like 48 states or 49 states that as soon as that decision came down, actually reformed their state level eminent domain laws as a reaction to that. So there's a very strong public reaction to that case. There's also a movie called Little Pink House. Kenzie, remember we watched that? It wasn't the greatest movie, but it was all about this case. It was all about this case of eminent domain. And so there was really an outrageous reaction to this on both sides of the political spectrum. Just this past Supreme Court term, there was a case out of New York that the petition for cert, the question presented on the petition for cert to the Supreme Court was directly to overturn Kilo. I was watching this very closely, and I fully expected them to at least grant cert. I wasn't sure what the outcome would be, but grant cert means that they're going to hear the case. And cert was denied, which I was very surprised about based on some of the land use decisions over the last decade of the Supreme Court, how we have it now. I was really hoping that they would do it, not necessarily not for a particular view on the case, just so I could, this live in action Supreme Court arguments over this, land use stuff. I mean, that's exciting, but that's Kilo. The second thing I forgot we said, COVID, rent control questions, but I'm gonna pass on that one. I just don't know. I'm not sure the specifics of the question or exactly what my answer would be to it. But yes, there were certain rent control decisions or abatement of rent during COVID. A lot of that was done under emergency powers at the state levels or the municipal levels. And so in a declaration of an emergency, that gives heightened authority to state and municipal democracy in action decision making to take some of those more drastic steps. And obviously that was controversial, right? But obviously it also played out in this conflict between democracy and rights. I'll go pink shirt, green shirt, and then.
Well, Brian, this is, I didn't know it, security donation, I'll start this passing, that's what it says here, I didn't know we had that.
All right, it's passing it around. Gentleman right here. Wow, thank you.
The land use business, real estate developer for the last entire career, 40 years or so, and been on the abuse end of this over-regulation so many times. And unfortunately, I
So yeah, the question is there a reason why different governmental agencies might be more aggressive or less aggressive in trying to regulate private property rights, private liberty rights? The answer is it completely depends on the context of the other politics and the level of government. Is it local, is it state, is it federal, right? Who's the administration, right? What are the kind of marching orders of that agency coming from elected representatives? And it depends also on what the target is, right? Like I said, maybe they're being aggressive because some massive megacorp is dumping pollution in our lake, in which case that's okay. But maybe they're doing that because of some NIMBY reason, right? Not in my backyard reason. We just don't like those kinds of people in our neighborhood or whatever. Or we like these people, there's some kind of favoritism. We like these people more than that. Maybe, that's possible for why you might be aggressive or less aggressive, for why more aggression might be a good thing, or less aggression might be a bad thing, or less aggression might be a good thing, more aggression might be a bad thing. Right, it all depends on what's happening with that. And a lot of it all comes back to the politics of it, right? And who's calling those elected, who's calling those shots at the elected representative side of things, and what are the real big public policy concerns and issues that they're trying to address. But again, it's all playing out in this context, right? Democracy, rights and democracy. All right, sorry, thanks for your patience.
Yeah, I think I speak for many of my neighbors here that you've been keeping us on the edge of our seats.
Ha! Ha!
Yeah, but it, but this evening's damn hard.
Ah.
But I might want to point out an observation from what I've learned from you tonight, and then I'll ask you hopefully a fun question.
Okay, observation and question. I think this will be the last one. If you have questions after this, feel free to come up. We can chat a little
So
bit.
the observation is, what I'm learning is, if I want to protect my rights, I better pack the town council with my golf buddies. So that's one way to skin this cat. The question I have for you is, if James Madison had been Doucette about sulfur, how do you think he would have ruled?
If James Madison was Judge Richard Doucette, how would he have ruled for the Killdozer case? I like that question. I'm a Madison guy. Madison was the most scholarly of the founders, so I really find him the most interesting. The answer to that, very lawyerly answer, is it depends which Madison. Okay, there are many Madisons. There are Madisons during the Revolutionary period under the Articles of Confederation, where he says there's too much democracy, right? And that's one of the biggest problems. It's going to undermine the entire American revolutionary experiment, is that there's too much democracy. That James Madison would have, I think, ruled also in favor of Granby Industrial. Now, why is that, right? One of the great ironies is some of the Marv, culture out there is very anti-government, but Marv was really in his lawsuit trying to use the government laws and the government decision-making to prevent his neighbors from using their property how they wanted to. So in that sense, that democracy in action, Madison, right, Mr. Too Much Democracy, would have said, no, let them do with their property what they wanted, right? But then Madison, he evolves over time. He becomes the third president of the United States, and he's a lot more comfortable with governmental power to do certain things. And that Madison, when he's actually in power, in control, has to address certain important, critical public policy issues, might have been more on the, allow the legislature to make that decision in that case, maybe come out on the other side of the Doucette decision. That was a good one to end on. Yeah. All right, well, thank you all for coming out here tonight. I hope you had a good one.
So is there a First Amendment argument that was made for this? Oh, wonderful. She's right. Well done.
Madison, him in Washington.
I have the traditional. You know what a traditional.
Hey, thanks for coming out,
I don't know if I
guys.
have